Well, thanks everybody for joining us again here today on the NutriStrong podcast, Fireside Nutrition. We're very excited today to be joined by two partners from the fabulous law firm Amin Talati Wasserman, Amanda Roach and Angela Kalsi. Thank you so much for both of you joining us today. Really appreciate it.
Thanks. Great to be here.
Excited to be here.
Awesome. And one of the things we always like to start with is tell us a bit about yourselves and your background. And I'm always intrigued by regulatory lawyers, and we talked to one of your other colleagues about this. When did you wake up? What day was it you woke up and you said, I want to be a U.S. trademark and global trademark attorney?
Oh my God, that's so funny. I'll start. This is Amanda. And so yeah, I lead the practice group. I've basically been in trademarks my whole legal career. There's kind of a running joke in my family, though, that I was supposed to do this. There is a family legend that my great whatever uncle invented Dr. Pepper. And he yes, so he was a dentist in Texas. And this is way back in the day when, soda shops were becoming all the rage. And I think Coca-Cola just launched. And he developed this recipe for carbonated prune juice, which is, it's funny, he's a dentist and he's developing this super sugary drink. But he didn't really think anybody would want it because it's just this, it's another Coca-Cola essentially. So he gave it to a friend of his and was just like, do what you want to do with it. So this guy kept it and apparently then sold it to a beverage company years later, and it eventually became Dr. Pepper. And it's funny because the only thing that really has any length to my relative is the name, because his last name was Pepper. He was a dentist, so he was Dr. Pepper. So that's kind of how, and it's kind of the lost trademark. I have absolutely no financial interest or whatever in Dr.
Royalties off that? No?
Love the beverage. But it's funny, it's family lore. I mean, I read it in a family book. It was written down, but I checked the Wikipedia page for Dr. Pepper and it's a different story. So who knows? But the running joke was when I became a trademark attorney, my parents were like, yeah, that makes sense. So, yeah. And I've been doing it ever since I graduated law school. This is where I've been.
That's great, Amanda. Angela, how about yourself?
Well, I'm actually related to Mr. Pibb. No, just
really?
kidding. No. No, nothing nearly as interesting. No family lore, but I was always interested in intellectual property. I kind of knew when I went to law school that I wasn't as much interested in the litigation. I was more interested in the creation of ideas and inventions and brands. So, I'm really excited that my first opportunity joining the legal world was at a trademark firm. And it's basically, I've stuck with it my entire career. So I love brands, all aspects of them, and really happy where I landed.
Fantastic. And from your perspective and a legal perspective, what exactly is a trademark? We're going to start super simple. What is a trademark? And why is it important for companies in any industry? We're focused obviously in dietary supplements and nutrition and health products overall, but what is a trademark and why is it important to pursue one?
That's a great question. I'll take that one. So yeah, a trademark, it's essentially a piece of property. It's a part of this group of rights called intellectual property. So it's, stuff you create with your mind that is going to be super important for your business. And they can be any kind of, there's different kinds of trademarks. Their whole function, though, it's really designed to trigger an association in the mind of your consumers, to connect, like the trademark connects your products with your company and your company alone. So, it's really designed to make your trade, like the idea of a trademark is so your company can stand out amongst the pack, because how many supplement companies are out there, right? You want to make sure that you are recognizable, that that people remember you. So that's really why trademarks exist, and that's why they're very important to obtain. And a trademark can be a word, it can be a design, it can be a logo, a phrase, or a combination of all of these things. And there is law out there, obviously, to protect your trademark, because you want this asset as part of your company, and it can become, like I said, a very, very valuable asset. And trademark law is out there to kind of keep confusion out of the minds of consumers, because, you know, the law doesn't want a company confusing one company with another. That's why a trademark kind of becomes your fingerprint. You know, no two fingerprints are identical. And that's kind of the same idea with a trademark, is to kind of separate everybody in the same industry. They also, over time, a trademark, it gives this promise to consumers of a consistent level of quality. It helps them decide to purchase your goods versus somebody else. And it also kind of helps them figure out which brands to avoid. So that's kind of the overview of essentially why trademark exists. And, you know, people might be reading something, okay, that's great, like I'll get the trademark, but like, you know, financially, really, what does this mean? So yes, and that's when I always say, like, it does cost money to get trademarks, right? You do have to spend money to get these things. You know, lawyers like us charge fees for making sure we set up your protection correctly. And then there's this body called the United States Patent and Trademark Office in the United States, which kind of governs the registration of all of these brands. And Angela's going to talk about that more in a second. But it's funny when you look at trademarks, we try to encourage clients to think of it as a capital expenditure versus an operating cost. Mm-hmm. And what that means is, you know, capital expenditures they're those kind of one-time big purchases. You purchase an asset. And what I like to tell clients is, like, think of it as like a trademark is like your warehouse. You know, you're going to have all this product that you need to house somewhere, and you need, you know, 4 strong walls, a really good roof, and really good security. And if you spend really good money putting that in place, you know, that warehouse can last for decades. You know, it's the same thing for a trademark. If you really start spending the money up front, you do your research, you do your homework, you get a trademark that's available, that's strong. That trademark's can last you potentially, I mean, it can last you forever. I mean, you can keep having a trademark, renewing it for every 10 years for as long as you want. Versus, let's say, like, you're like, you need the warehouse, you want the warehouse, but you're like, I just don't want to spend money on the warehouse. So you hire somebody who maybe has shoddy materials, you know, maybe they're kind of leaving, you know, holes in the roof. Maybe you get kind of a cheap security system, and then the roof caves in, rain comes, ruins all of your product in the warehouse, or somebody comes in and steals product from you. They break into your house and make their theft. So that's where operating costs come in. If you don't lock down those capital expenditures, if you don't have a strong warehouse at the get-go, your operating costs are going to go through the roof, right? Because you're going to spend all of this money cleaning up the mess. And it's the same thing for trademarks. That's why we kind of say, like, yes, it is an expense, and sometimes it can get expensive, but if you do it right at the get-go, you're spending way less money on the back end, and that protection will last you for decades.
When you talk about the lasting for decades or year upon year, once one files, how long does it take? Take us through sort of the process of, once you submit the paperwork to the U.S. Patent and Trademark Office, how long does it typically take in the current climate?
Sure.
To get approved to say, yes, your trademark is, and what's the term even? Is it authorized? Is it approved? Is it accepted? Is it not objected to? What is the verbiage around? Yes, I have my
all great questions. All great questions. Yeah, because, you know, a lot of times companies think, oh yeah, we want to use that. Let's trademark it. And they're thinking it's just, okay, file this one piece of paper and then it's done. It's actually a quite involved process from the time you lodge an application until the trademark is granted registration. So the verbiage there would just be registered. There are various steps it goes through. First of all, and this is specific to the US, but basically every country's trademark office follows the same general steps, maybe in a different order, but, you know, essentially they're all the same hurdles that a trademark has to go through. So in the US, first you have examination by a USPTO examiner, and these are folks working at the USPTO who just look for things that are wrong with your trademark. It could be, you know, it needs to be described a little bit differently, or something as major as, no, it's too close to something that's already on the register. You're going to create consumer confusion. So, you know, that occasionally can go on for years. Examination times at the USPTO right now are I think at their longest than I've seen in a really long time. The standard for many years was 3 months from the time of filing to getting that first examination report. Now it is 6, 7, 8 months. We are just seeing that number slowly creep up as time goes by. So, unfortunately, they've got some backlog there, and all
And is that
trademark
a queue?
holders.
So once you get in, the clock starts that at least if someone shows up with a similar mark, with a similar description, 2 months later, you get the preference because you're in ahead of them. Is that at least some
Absolutely.
priority given in that respect?
Yes. So it is always advisable to file sooner rather than later,
Okay.
because even if you're going to sit in a pile for 6 months before anyone at the office even looks at your trademark, you do retain that priority date, the date you filed. And actually, it happens a lot, what you just described, where an earlier pending application was filed maybe a month before yours, but that one hasn't been looked at yet. So, it can lead to this suspension where your trademark is blocked based on a prior pending application. But since that one has not made it through the process yet, it just suspends your trademark. Maybe someone who filed after you is blocked based on you, but they're suspended because nothing's made it to registration yet. So we've had marks sit in suspension for years, unfortunately. It can occasionally get pretty backed up.
Yeah, usually, hopefully that's not the norm, and we don't have, luckily, few cases where that happens, but it just, I guess, take away, file early because you're going to be waiting a while. Yeah.
Yes.
And then once your mark is registered and granted, and you feel good about yourself, you've paid the money, you've done the work, you're through the gate, fantastic. What type of flexibility is there to expand the mark because it has an expanded meaning in a business environment, right? It's always fluid, and brands take on different products, different service types as they grow. So how do you accommodate for the trademark expanding its scope
It's a great
as
question.
business grows?
Do you want me to take it? Is that okay?
Go for it. Yeah.
So we get this question all the time, and especially, because companies do grow, they are interested in new products. And because we represent so many startups, they're always thinking ahead, what can we do in 3 years, 5 years? And we kind of encourage those conversations to happen early. Like when I'm talking to a new client who's coming in and is like, basically, what's a trademark? What do I need to do here? I say, okay, so we know you're going to do supplements, and that's really there. So when we're filing this trademark, obviously we're going to claim dietary and nutritional supplements in class 5. That's kind of the standard. It's super broad. It encompasses all the different kinds of dietary supplements you could possibly want. So if you're putting out a B vitamin right away, that's covered. So your use of this B vitamin product will support that trademark down the road. And then later you want to do a vitamin C product. Well, that's also going to be covered because it's still a supplement, right? But the crux comes when clients are like, well, wait a second, what if I want to do a beverage? Like, what if I want to do a sparkling water beverage, down the road? We're kind of thinking in that realm. Or maybe I want to do a protein powder or something, down the road. So once you file for an application and you put those goods and services down on paper and give it to the trademark office, you can't expand that. It's you can shrink them, you can make them more specific, okay. But you cannot expand. So that's why we tell clients, also because what Angela talked about, it's taking so long to get a registration right now. So, even for your supplements, you're waiting 12 to 18 months to get that registration certificate. So we say, think ahead, think 3 to maybe, 2 to 3 years down the road and file for what you think you might be putting out in 2 to 3 years. Because let's say that you're well, we have clients who are like, okay, so we're definitely doing supplements. I think we're going to do beverages and maybe we'll do protein powder. I'm like, okay, put all of those in there and then we'll see what happens. And then, because we can always take them out later, we can delete them. If we get to the point where we're getting close to registration and we have to do the last step, which is, prove to the PTO you're actually selling these goods. Mm-hmm. And they're like, we're not doing beverages and we're not going to do beverages for probably 5 years. We're like, let's X them out. Let's X them out and let the application go on. especially if they're, I mean, we do have some time to like keep filing extensions to show use. So there are some things we can do to kind of work around that. But like, if you think beverages was this great idea back in 2022, and then in 2025, you're like, no, there's no way we're doing this. Like, then we just say, let's just exit out. So moral of the story is, really try to think ahead, get that 5-year plan in your head for where your company might be, and then file based on that.
Does it also then assist with larger companies not being able just to continue to redefine their scope so they own the entire landscape, so to speak?
Yeah, I mean, that's kind of the beauty of the United States versus other countries, is the fact that you have to use your marks and you have to prove that you're using your marks. So like, you can file for every good and service under the sun, but before you can get that registration, you've got to, like, at least in the US, for US based, if you file based on you or intent to use, you got to eventually show them a document saying, look, this is my product. It is for sale on my website. To prove that you're actually using it. Plus, you have to sign an affidavit promising the PTO that you really are selling it on all your goods. And if it turns out that you're fibbing a little bit, maybe you're not actually selling it, then your mark can get canceled. So, So there's a little bit of checks and balances there. I mean, the big companies obviously have more funds to spend on the trademarks, but the playing field really is leveled when it comes to use, I think, at least.
And then when you talked about some of the pieces or components of a robust trademark strategy, so think 1, 3, 5 years out, what's your 5-year plan, and how does this mark tie into that plan on the descriptor side? But you mentioned some of the components, things like shape of the packaging and packaging. I'm always really intrigued as to things that I'm sure you see all the time, and hope you can comment on pieces that are missing that a brand might not consider part of a trademark that are absolutely otherwise part of a trademark.
Yeah, this is one of my favorite things to talk about because it's fun. I'm such a super nerd, but like, this is so fun. So yes, the shape of a package can be trademarked. It's what we call trade dress. So it's kind of this like, sister of a trademark. And it's basically kind of protects the overall look and feel of the product packaging, so to speak, like what the product's in. A really good example of this is the Coca-Cola bottle. Like Coca-Cola's old glass bottles that you see in the movies from the 50s and 60s, like that's trademarked, the shape of the bottle. That being said, like you really do have to be pretty creative. Like it can't just be you have a pouch that's, shaped kind of like more like a trapezoid versus a square. If there's other people using trapezoidal, pouches for sauces or whatever out there, that's probably not going to be protectable. And there's kind of this line also that this is when trademark law kind of starts to push into patent law a little bit, which Angela can talk about. But before we get to that, like there are other ways, like you can really make your company stand out from a trademark sense, because it's not just words, slogans, designs. There are sound trademarks out there. You can actually get a trademark registration for a sound. Like,
really?
Yeah. So like the Southwest Ding, that is a registered trademark.
I'm loving it. I'm loving it. You can.
Yeah. Right. Yeah.
I think
I'm sure McDonald's has that somewhere.
Oh yeah.
And the jingle probably copyrighted. But the also color, like Tiffany blue, that is a color that has been owned by Tiffany for years and years and years. And even like movement. So like Lamborghini cars, like they have the doors that go vertical. So there's a trademark on that movement. And if you go to the PTO, there's like a little cartoon showing how the doors open up. And that's actually a protected trademark too. And these are kind of getting out there, probably away from the land of supplements, obviously. But like, if it's something that's going to make your company stand out, I'm sure there's some sort of intellectual property avenue to help you, get protection for it and to monopolize it.
That's fascinating. That's really interesting. So if a dietary supplement bottle had gull-wing doors instead of a screw top, because I haven't seen that.
That would definitely be trademarkable. Yes.
Tip of the day for all of our listeners out there.
Yeah, right.
So we have the U.S. scene, and you're both heavily entrenched and involved on the trademark side. Now, how does a trademark work hand in hand with a patent? And when is something to be considered more on the trademark side versus the patent side? And I'm thinking of, with the dietary supplements, one of the novelties, one of the areas where companies try and differentiate is on delivery technology, whether it's on the encapsulation side or some other device, some other manufacturing or chemical process that is novel and creates better characterization or characteristics for the formula. So when is something, how does it, let me put it this way, what's the difference between a trademark and a patent? And what are some of the deciding factors for a company when they're considering to pursue one or the other or both? What is a tipping point one way or the other?
Definitely. Great question. So at a really high level, a patent protects inventions, innovations, improvements on existing inventions. Trademark is about branding. And, altogether, a strong IP portfolio will include protecting, the delivery method, the invention underlying that, possibly through a patent, as well as your brand, your logo, your company name. Those would be protected under trademark. There are, even though you want both of these types of protection, there are areas where they do occasionally butt heads. Returning to what Amanda was talking about the trade dress, what makes that protectable as a trademark and not simply, oh, this is how the product is designed? What the trademark office really looks for is, were there kind of arbitrary aesthetic choices made that make this a distinctive product design that is not purely functional? And one of the factors they actually look at, because they have this checklist of things they run through, is whether there's a patent associated with that design or with that method, or not that a method can be trademarked, but basically, if there's a patent underlying the product at issue that speaks to its functionality, it's inherently utilitarian because the patent protects that functionality there. That directly cuts against what a trademark is trying to do, because a trademark is supposed to be more than just functional. It's supposed to stand out from others in the doing the same thing in the industry. So the more distinctive it is, the stronger it is. And when it comes to product designs, they really have to be distinctive, non-functional, in order to be protected as trademarks. There's actually this whole spectrum of the strength of a trademark based on how distinctive it is. On the one end, you've got generic terms, like those can never be protected as trademarks. Like the word supplement for supplements, can't protect that. That's the name of the product. Mm-hmm. Then on the other end of the spectrum, you've got coined terms, like just fanciful names that people have made up that don't exist in the dictionary. And those are the strongest type of trademarks out there.
Okay. So instead of facial tissue being the generic term, Kleenex is the brand name, as an example. Would that be a good example?
That's a great
example.
Yeah. All right.
Yeah, if you every time I talk to a client about okay, well, how do I pick a good trademark? What's a good trademark? I'm like, think Apple for computers. Does an apple have anything to do with a computer? No. Right. So it's it's kind of counterintuitive, right? Because as a customer, you kind of want your brand to kind of announce to the world what your product is going to be, right? But from a trademark sense, it's kind of the opposite. You can suggest what's in the product, with how the product functions, how the flavor of the product or whatever, but you can't 100% describe it. And actually, the further away you get away from that, the stronger the trademark's going to be. And yet you're going to have to spend a lot more money on at the get-go, really training your consumers to associate this word with your product, with your company. But it's in my opinion, it's so much more beneficial to establish that and spend those funds early, because then on the back end, you just can kind of coast on your reputation. I mean, there's things you got to do to kind of maintain it, but it's that versus registering, let's say, a more descriptive mark, and maybe there's other people out there using it, because then you're going to have to really strongly try to differentiate your mark from everybody else's who's using it, but also there's going to be fights between the companies that are using the same things, and litigation, as everybody knows, is super expensive and not fun. It's no bueno. It's not good. Yeah.
So we talk about costs, right? There are legal costs, but as you mentioned earlier, some are outright legal expenses, like a litigation. But I've also seen where, as part of the result of that litigation, a brand and by extension a trademark are actually strengthened. So when we talk about the value of a trademark, you have that initial investment. You mentioned earlier, great point, I think, for everyone to always realize that it's an asset, it's a property. It goes on your balance sheet as an asset for your company, for your organization. It's not a legal expense on the income statement, as the same way there are other legal expenses like closing costs on a real estate transaction, as an example. So even though it's a cost and it costs money, there is an inherent value to it. Is there some magic formula or scale as to what a return on investment is for putting the money in to create that asset that you are able to share, or even a general range or guidelines when you say, if you spend the money, there's a 5-to-1, 3-to-1, 10-to-1 for the supplement industry. Maybe that's too granular, but is there a general guide to what's the return on investment for funding a trademark?
Yeah, that's a great question. So, it really depends on, of course, what you do with the trademark after you get it, because you can actually, you can register the trademark and just have it sit there. Like maybe you register the trademark, but then you don't sell any product. So then what's the trademark really worth? But there are companies that actually value, this is their one job, is to sit there and look at your trademarks, look at your portfolio, look at your sales, and actually figure out, like, they can come down with like, a range of numbers for how much that trademark's actually worth. Where we see it come more into play, and we don't do valuation services, but like there's companies, really good companies out there that do. But where we see it come into play is with when companies want to get investors, or they're on the chopping block, but in a good way, like to be sold. Like, they've garnered the attention of a larger entity that want to acquire them. So it's like those money, and the first question that, one of the first questions we always get asked is, how's the trademark portfolio? And that's something that we look at, it's, so do you have all these rights? Do you have them in all the countries you're selling in? Do you have your main brands? And I've seen, we're talking, millions of dollars worth of investments. I actually saw a deal go down the tubes because it was a 50-year-old company they've been operating for 50 years, selling their product, family-owned company, and then they got the attention of somebody, really had no intention of selling, but the deal looked too good. So then they went through the process of providing all the information they needed for their brand to be sold, and discovered they didn't have the trademark. They didn't have their company name trademarked, and it was like that was on all of their product, and the deal fell through because of one trademark. So it's like, that's something that, like, if you can't put an actual, like, your finger on an actual amount for how much is this trademark going to be worth in 5 years, you're going to get some sense of how valuable it is when you have investors come calling and when you're seeking investments. And, there's a lot more that goes into investing in a company versus just the trademarks, but it is a big part of it.
For sure. And you mentioned sales being one of the variables that's factored into these algorithms and formulas. If your trademark is challenged, heaven forbid, and there's litigation involved, and you as a brand win the litigation, is that also, it certainly strengthens the mark intuitively, but does it actually add value to the mark as well? So you've got the sales, you've got consumer awareness and growth in those respects, and they factor in. But if you win a couple of trademark wars, so to speak, does that also get factored into the value of wow, this trademark's really strong? Do people pay attention to that?
I think they do. I mean, because it's funny when we see, like, if a client's like, I really want this trademark, and we do a search for it to see if it's available, and we see that, like, conglomerate A actually has a very similar trademark, which maybe it's a little, we're like, yeah, it's borderline. Maybe it's this could block you, maybe it can't, but we're like, this is a very litigious company. Like, look at the decisions they've won, for their trademarks. So it kind of becomes, I would say, a deterrent. Let's say you take your trademark to battle and you win, right? It becomes this kind of, if the company has a lawyer that's worth their snuff, they're going to look at those decisions and see that, like, we probably want to stay away from this trademark in this area because these guys have the trademark, and not only do they have it, they're winning battles for this trademark.
So all
it
that's in
kind
the
of is
public domain as well?
I'm sorry, what was that?
Is that all of that in the public domain as well? So you can see the battles that are being fought?
Yeah, I mean, trademark decisions, big trademark fights are getting written about all the time. There's a big one going on right now between Grubhub and Home Chef that would just popped up. We're writing about that later. So yeah, I mean, they're written about in the news. But yeah, you can search the USPTO if you want to search oppositions and cancellations, which are like mini litigations to get rid of trademarks that happen. That's all public information if you know how to search. But yeah, but it's because a lot of times there's a lot of David and Goliath stories out there with trademarks, the big company trying to stop a little company. And so those get written about.
What's your favorite David and Goliath? Since you are trademark nerd, self-proclaimed, what is your favorite David and Goliath? That's in the public domain that you're able to share. Do you have one off the top of your head? If not, no worries. But if you had one.
I don't think I do have one, Angela. I mean, the Grubhub Home Chef one is interesting because it's like, Grubhub was acquired by this really large company, and Home Chef was kind of coming on being like, we were here first with this logo, and it's the house, essentially the house logo with the fork and knife, right? So they were really trying to like assert their rights, but then come to find out that Grubhub actually had been using the mark before them, which means they had prior common law rights. So it kind of shot David in the foot, so to speak. David shot itself in the foot because it was asserting that it had these prior rights when maybe it doesn't. And this is all still pending. So like, more information could come out about the first use date, but that's kind of what we're seeing right now.
Okay, so he misfired the slingshot on that one.
Yeah, maybe. We'll see in the end, but it might be.
Perhaps. That's really interesting. And then other than having, fantastic trademark attorneys such as yourself, it really interests me about what gets registered and granted. So to me, a house with a knife and a fork, that seems like super generic. How can that get a trademark? That, like the flip side, you said the more obscure it is, the better, and you gave some really good examples of that. But how is it that some of these things get through?
Yeah, I think do you want to talk about that, Angela? Especially like how to get descriptive marks. There are ways.
How does a house and a knife and a fork say, yeah, that's so novel and special? Doesn't seem that way. So how do you work through that as a talented trademark attorney?
Great question, because, going back to what I was saying earlier about that spectrum from generic terms to completely fanciful terms, the reality is most trademarks fall right in the middle of that spectrum because most companies don't want to invent a term out of thin air and educate their consumers on what that is. So usually you go for something that bears some relation to what your product or service is. Obviously a consumer sees the fork and knife inside a house, they have a pretty good idea that that's going to involve dining services or food delivery or something of that nature.
Mm-hmm.
So, there's kind of this inherent battle really between marketing teams and trademark attorneys because, the marketing folks want to really quickly and efficiently communicate to consumers, what the brand is all about. But of course, as trademark attorneys, we're thinking about that spectrum of trademarks and trying to push them further in this direction to make it more distinctive. And it often comes down to whether something is categorized as a descriptive mark or a suggestive trademark. And Amanda kind of touched on that before, but it truly is this blurry fine line between what is simply describing the underlying product or service and what is merely suggesting the service. So, in this case, you could argue that the image of a fork and knife inside the shape of a house suggests to consumers that, food delivered to my home. That seems to be what's being communicated here. A lot of times trademark attorneys are left trying to argue that something is suggestive, whereas the trademark office says, no, this is descriptive. Mm-hmm. But it's not the end of the story if a mark is found to be descriptive, because even descriptive marks can be protected. It just requires a little extra work. Basically, they have to show that despite being inherently descriptive, they have nonetheless been using it long enough that consumers are aware that it associates that image with that brand. You know, it's not just a generic logo that's out there or set of terms, that they do in fact identify it as coming from one source, you know, that particular trademark owner. So that, you know, you can put forth a ton of evidence of sales and advertising expenditures and what have you to try and convince the trademark office that your descriptive mark has risen to that level where it's acquired distinctiveness. But also there is a presumption that after 5 years continuous use in commerce, you've reached that level anyway. So it's kind of playing that waiting game with your descriptive mark. But getting back to your question earlier about, you know, policing a trademark, do you really want to have to fight others in the marketplace for use over a descriptive term for 5 years in the hopes that the trademark office will then grant you exclusivity in it, you know, by way of a claim of acquired distinctiveness? It's, you know, sometimes a long shot. So again, there's that
shot, yeah.
Exactly. So,
yeah.
You know, picking those marks that are more distinctive, suggestive at the outset is always going to be safest. But of course, when you're Grubhub and you've got the money to advertise and educate consumers that your descriptive words are associated with your brand, you know, you've got more power to build that consumer awareness and recognition and acquire distinctiveness in what may be a descriptive mark.
And then with that, we talked about descriptive versus suggestive. On the timing side, we've talked a lot about the U.S. domestic market and filings with the USPTO. And certainly that's an area that you both know well and have done a lot of work in. How does that port to other jurisdictions? And being on the services side, you're service providers, we're service providers, completely different areas. But one of the big things that I always find with the early stage firms is that they all want to go global. They might have a staggered plan for how they're going global, but we want to conquer the world. Okay. How would you like to conquer the world? In what order and sequence, please? So that we can match what we're proposing as scope for you to do for the services we offer to meet those needs and that timing. So when those firms, even though they may be U.S. domiciled firms, they have aspirations of going global with their products, especially if they get traction, momentum, and success. So how should one, as a brand, when one of these firms approaches you, how do you help them navigate how to roll that out over time so that they are protected? And then if they're filed in the US, but say not filed in the EU or the UK, and someone else files in the UK after them, but before them in the UK, but after them anywhere, how does that play into how you roll that out? Because I find that's where I still get confused on trademark stuff big time, and that's where I know our clients get confused on IP, the timing of the filing, where it happens, and who gets first rights globally, even if they don't have first rights in a given country. Sorry, a lot of things I
No, it's great.
at the wall there, but
we got the answer. So
okay.
Yeah. So yes, I mean it's there. Yes. Okay. So if you're filing a new trademark, let's say you come to us and you're like, I want to file for a widget in the United States for dietary supplements. We're like, great. We search it. It looks clear in the US. We file for it claiming dietary nutritional supplements. So after we file, once you get that filing date, you have 6 months to take that trademark and extend it to a multitude of countries and still be able to claim your US filing date. So even if you're filing 5 months after your trademark was filed in the US, you kind of get to leapfrog over the line of people who came after you. Because if you have an earlier filing date, you don't have to worry about marks filed after you for several months in order to kind of make sure that you're not going to get blocked by those marks. Okay. So that's one consideration. And it's this lovely thing called the Paris Convention, and countries who are party to the Paris Convention all enjoy this priority right. So let's say that you're a UK company, you filed your trademark, you give us a call in the US and be like, hey, my client filed for, I don't know, gobbledygook supplements in class 5 in the UK, we want it in the US. as long as we're within that 6 months, we can claim priority based on the UK filing, which again allows you, it gives you more rights, more oomph, because you're kind of cutting out all of these people who came before you for a certain period of time. So timing wise, if you're a US person coming to us, like we always, and we remind our clients of this, you know, we remind them when we file, like if you want to file abroad, if that's in the cards in the next 6 months, you know, let's do it, because we can claim priority and get you an early filing date, and get you, you know, it's a more secure way to get your rights. We do send reminders to our clients as that deadline approaches, just so we can kind of keep reminding them. Now, the question is, okay, Greg, so you know you want to file globally, but where do you want to file? So, you know, this is a big thing, because like obviously there's a million countries out there we can pick from. We have a list of, you know, the most popular countries. And for US clients, we find that like Canada is a big one. And Canada's really important because I mean, I don't know if you're probably aware of this, but like the Canada Trademark Office is taking a very, very long time to register marks right now just because of the backlog. So I think for like 3 years, we're now waiting to, after filing an application, getting that first examination report. So we do recommend filing for Canada early, even if you're not totally sure.
We forget about the things we filed for, and all of a sudden they show up like 2 years later, like, oh yeah, I filed for that.
Yeah, exactly.
It's no longer relevant, but at least we have it now.
Yeah, exactly. And sometimes that happens. Sometimes clients are like, man, we don't like this brand anymore. And we're like, well, what do you want to do with the pending application? And we, you know, discuss what to do with it. But so the most popular countries, I mean, you know, the Canada's like a big one. Mexico is a big one, especially for supplement companies, who a lot of them get their some of their ingredients from Mexico. You know, so that's another consideration. The EU is a popular one because one filing covers, I think it's 27 countries right now. So it's kind of like 27 countries for the price of one. An expensive one, but it's definitely, you're getting 27 countries with one filing. The UK, you have to file separately now because it's no longer part of the European community, the European Union. But that, again, that's a big one. It's an English-speaking country. You know, you have the language that you're using to promote your brand in the US is going to be pretty much the same that you're using in the UK. Australia is a big one, and then China is huge. And we can talk about China's a whole nother world. But you know, and I can go on about which countries are really important. But the main thing is, like, I ask clients, well, where do you want to sell? Like, you know, where are your eyes looking right now in the world? You know, we have one brand, they're in the US, and then they're in like all the countries in East Asia. Like they have they really don't care about Canada. They don't care about the EU. They are focusing on the markets in Japan, in Korea, in Taiwan, in China. And so that's where we filed, you know, so it's like, where do you see yourself selling? Where are you going to be spending your money to promote your brand? That's number one. And then we try to obviously say, like, you know, let's think about a couple years down the road, you know, where are you going to be in a few years? Because you can file there now and use it later. And that's kind of where the US is very different from most countries around the world. So the US, in order to get your registration, you have to show that you're using it. That's kind of a given for most applications. I mean, but there's a couple, you know, kind of foreign doctrines that allow you to kind of scoot in without a showing of use. But for the vast majority of US applicants, to get the registration, you have to show use. But in other countries, it's not like that. In other countries, it's a race to the trademark office. It's a first to file situation. So if you file first and you get the registration, you get those rights, regardless of whether you're selling the mark at the time you apply for or register the mark. So that's something to think about. Now, those marks, those registrations aren't completely, you know, they're not bulletproof, because you eventually do need to sell product. And this comes along where, let's say that you file in the European Union and it's been a few years. And then somebody comes along and is like, wants that trademark, but they're blocked by you in the European Trademark Office. If enough time's gone by, they can ask you to prove that you're using that mark in the European Union. And if you can't, your mark could get canceled. But it does provide, filing abroad does provide a cushion, right? So you can have a few, more so than the US, you can have this bigger cushion of time to get your product to market in these other countries and use your product in other countries. It's not as immediate as it is in the US. Does that answer some of your questions? I know I kind of talked for a bit, so.
Angela, anything to add? Looks like you're looking to
Yeah, just piggybacking on that, most countries in the world, it's 3 to 5 years before it becomes vulnerable to a challenge on non-use grounds. So again, thinking about those timelines, foreign countries where you might do business in the next 3 to 5 years, it's worth locking down registration now. Like Amanda said, it's a race to the trademark office because the rest of the world is pretty much first to file when it comes to trademark rights. So that's really the sweet spot in terms of choosing which countries to protect. And also, you know, in terms of where to file trademarks overseas, you also want to look at where are counterfeits coming out of? You know, where is that a problem? Because with a registered trademark, you can record that with the local customs office and try and fight, you know, counterfeit operations that are affixing your trademark, your brand onto their counterfeit goods and sending them out into the market. So that's something to consider as well.
And what about the issue when, let's say you filed on the counterfeiting piece or the fraud piece, misrepresentation side of things, if one is filed with the USPTO, you have a brand and all of a sudden your relative calls you up and say, hey, I was traveling in Asia and stopped in Beijing and the local retail and I found your product. I didn't know you launched in China. And you as a brand say, oh, neither did we. What when there's nothing filed, to your point, what is the recourse? What can a brand do? Or is it, I better file right away now, and that's the only recourse?
So, you know, and jump in at any point, Amanda, but
Sure.
it's, you know, unfortunately that happens quite often. You know, it's clients never like when, you know, they find out there's a trademark squatter or a counterfeit operation that's registered their brand in another country.
A trademark squatter, that's a phrase.
It's an actual term that unfortunately gets used too often. Like, yeah.
There are people and entities who I think their entire livelihood comes from trademark squatting.
Wow, who knew?
You know, in fact, there was recently a change to the law in China where you can now oppose a trademark on bad faith grounds or seek to cancel a trademark on bad faith grounds. That I think that used to be available, but it was virtually impossible to achieve. Like you may have seen stories in the news that, you know, Taylor Swift couldn't get her own name registered in China because a trademark squatter had got to it first. So, you know, fortunately, we are seeing that with those changes in the law, it's a little bit easier to go after someone who, in bad faith, registers another company's trademark. So that's really been helpful in improving chances of success. But it is still, you know, much better to just lock down that trademark ahead of time than to try and negotiate with a squatter or, you know, lodge a whole cancellation petition, you know, in a foreign country to try and get those rights back. It can be a drawn out process.
So true. And like, and when we see the squatters come up, there's usually two goals for the squatter, right? It's like, you know, why do this? So they're either going to sit there, they're going to file for your mark, they're going to get it registered, and they're either going to, one, put out an inferior product, which is a serious problem. I mean, let's say, especially for supplement companies, you know, because you guys, everybody wants to have really high quality goods. But if there's somebody in China who's like, oh, this, you know, widget supplements is so cool, I'm going to like register that mark and put out my own widget supplements, but like they're using, you know, really not great ingredients that could actually be harmful to the consumer, that sometimes can come back to the actual US person who owns the mark, the US company in certain circumstances. Automobile parts, that's another thing, you know, counterfeit automobile parts, you know, being registered, you know, being produced under a certain trademark, that's also a huge safety issue. So they're either going to do that, or what they're going to do is they're just going to sit on it until you call them and pay them money. And that's generally, that happens quite a bit. So, and sometimes we hate it, but sometimes it is cheaper just to pay them to make them go away. But now, since, as Angel was saying, there's now this process in China where it's easier to, like, you know, call these people out because they're doing something they shouldn't be doing. It's like, you know, like, you cannot, don't sit on our trademarks, leave us alone. But like,
Do the authorities there then act and enforce this law, or do they get fined? Do they get jail time? How does it work?
yeah, so so usually their trademark will get canceled. I mean, so it's like basically like their trademark, the squatter's trademark ceases to exist.
Okay.
That happens, but there are sometimes, especially in counterfeiting scenarios, where they're finding a lot of counterfeit goods, not necessarily with the trademark office, but yeah, there's jail time, there are fines in some circumstances where the squatters can get in a lot of trouble. Yeah, go ahead.
We've had a couple of, clients who discovered counterfeits in China, and, luckily they had registered their trademark with the customs office, coordinated with local officials, and actually raided, this counterfeit warehouse. And then it's always wild receiving those reports and, getting to tell the client, like, here's a police report from China that, they got 30,000 SKUs of this knockoff product. And, we want every case to be that successful, but it is difficult to enforce against counterfeits overseas a lot of times. So yeah, just locking down that brand protection is going to allow you every arrow in your quiver to launch a raid like that, and go take down the counterfeiters.
Take them down, take them out.
Yeah. So, and there's other things too. Like, let's say that you are registered in China, or you have your registration, but like, you want to make sure that nobody's going to come along with something similar. So there are trademark watch services that exist. So like, let's say that you're operating in the U.S., but you really want to keep an eye on what's going on in China, who's filing what in what classes.
Mm-hmm.
There's services you can call them up and be like, hey, this is my mark, these are the goods, like, I want you to tell me every single trademark that's filed or published in this country. And then you get reports, like, and this is something we do for our clients. So we'll get the reports usually, and then we look at it and be like, yeah, this mark's a problem, we need to do something about this. And that, yeah, and it alerts us, and it gives us the deadline, because there's only you only have a certain period of time in which to kind of file a formal action through the trademark office usually. So that gives us, the heads up, and we can talk to the client and figure out if this is something we want to fight. But yeah, that's part of policing your brand, and, making sure that, bad guys who want to take advantage of all the hard work you've done, like, don't get ahead.
For sure. And then when it comes to the counterfeiting, etc., how do URLs and web addresses factor into a trademark? Would you suggest filing the brand with the URL if there is one established and owned by the brand? Or, because to me, a big part of the brand awareness or the promotion of the brand is the web address. So how does the web stuff, even from a Twitter handle, Instagram handle perspective, how does that factor into the trademark and the brand protection?
You want to take that one, Angela?
Sure. Yeah. So, we see this come up a lot in the enforcement side. Basically, if you have a registered trademark for your name and someone buys a domain name that is that same trademark, there are actions you can institute to get that domain name transferred over to you, or, basically use of a domain name that is use in commerce, especially if they are selling competing products at that website that they've set up there. So it's very much actionable. If you've got your registered trademark, someone uses it in a website domain name, or even on social media pages. I think most of the social media sites now do have a really straightforward takedown form where you can say, this account has, is using my registered trademark as the name of its account. And so you literally just plug in the link, the number of your trademark registration, so that they can fact check it. And theoretically, they then, should take it down. We find that there's inconsistencies in how some social media sites will react and how quickly they'll actually take action. But it is very much the case that trademark registration will protect your brand on all of those platforms.
Wonderful. Well, we've covered a ton of ground today. Was there anything else before we wrap up that either of you wanted to mention? The floor is yours.
Maybe we talk a second about CBD.
Sure.
And cannabis, marijuana, all the fun stuff. So yes, so this is kind of in the US, and Canada, you guys are the enlightened ones. I mean, you guys have your trademark office open for all of these filings, and your CBD goods with THC are getting through very easily. It's not so in the US. And I'll keep this really brief, but like the history of CBD, let's say you have a product with CBD in it and you want to file a trademark, and you either put in your goods or don't put in your goods when you're filing a trademark that, yeah, this has CBD in it. So the rule is, if it goes in your mouth, or in some cases, we've actually had clients ask about CBD suppositories. That's a thing. If it goes in your mouth, if it goes in your body, that way it's ingested, you cannot get a trademark registration for CBD goods. That's like the flat rule. And we're really hoping that's going to change. Yeah. The thing is, though, there is, I don't want to call it a loophole, because it's more than a loophole now. You can, if you have a topical product, like an oil or something that has CBD in it, you can actually get a trademark registration for something that's topical, as long as you put this magic language in it. So like, let's say your widget, your brand is widget, and you're filing, you have a wonderful cream with CBD in it. So you would file for non-medicated skincare, namely body creams, none of the foregoing containing more than 0.3% THC by dry weight. And you have to say it's derived from hemp. I can, obviously if there's questions, like, we can look it up and people can find it, but CBD is slowly coming to market in the US, and it is a legal thing if you do the topical stuff, but definitely stay away from ingestible, from trying to trademark marks for like ingestible products for any kind of supplement or anything with CBD in it. Different in Canada, obviously.
Mm-hmm.
Yeah.
Except if it's being developed as a pharmaceutical, then likely a different strategy there when it comes to IP filing and so forth.
Yeah, because you do have to say, if you want that topical cream, it can't have a therapeutic function, and obviously can't have a medical function. It's got to be just more of a cosmetic application.
Okay.
Yeah.
That makes sense.
Yeah.
Very good.
Yeah, the
okay,
US.
Super. Oh, sorry, go ahead.
Oh, just, the USPTO just takes a really conservative approach towards interpreting what goes on at the FDA. So a lot of times it's lags behind what you actually see in the marketplace and what consumers are interacting with. So that's one area where we're hoping to see more development coming down the pipeline, and hopefully the USPTO catches up.
In terms of CBD brands, though, and supply chains, whether it's branded ingredients or finished consumer branded position products, that's where you all would help tremendously, I'm sure, in navigating that, understanding that. And I think one of the things that I've seen, this is with CBD in particular, this is where it is now, but also prepare for where it's likely going. And it's
exactly
a bit of a moving target. It's always a fluid situation, but at the same time, it does appear that things will continue to open up and become more accessible.
Yeah, that's what we're hoping.
It's going painfully slow in the US, but I think it will get there eventually, one way or another.
I think we will. It's just, it's and we're trying to come up with alternative ways to get our clients trademarks, through, and one of the things we do is we're like, if you can produce a product under the same trademark that doesn't have CBD, like that could get through. Like we could argue our way through that and get that registered. Okay. State registration, you can actually file trademarks with the states, which is a little bit like the Wild West right now. Like it seems like the rules are changing for that all the time, but that's also a possibility. If you wanted to get some sort of trademark protection for CBD, or in some cases even THC goods in certain states, because it is legal in certain states. Yeah.
Okay, super. Very, very insightful, very fascinating. Well, Amanda and Angela, I want to thank you both very much for your time today. Really interesting topic, covered a lot of ground, and thank you so much. Really appreciate all the insight you both provided.
You're so welcome.
Thanks for having us.
Yeah, thank you.